It's because your competition has to be the primary thing that you do. It can't be secondary to your motorsport.
Oh, yeah, that makes sense. I agree with that decision.
I agree.
Yeah, his sister was an athlete trainer.
Okay, but there are some more just that you've seen that.
Just anyway, just before you go
Take it away.
We're ready? Good afternoon, my name is Lindsay Earls, and we are about to do a presentation on drug testing in public schools.
I'm Jake Ivey, and first what I want to go over is the different methods for testing for drugs. There's many different methods used by many different organizations. You got hair, blood, urine, saliva, your breath, and sweat. In schools, the drug test, from what we found, drug testing was done mostly for, used mostly for preventing the drug use than for actually proving guilty of people who use drugs. I found that kind of surprising. Urine testing is the most common form used in schools. It usually, a group of maybe 2 or 3, could be more, subjects are going to be called out of class, sent to the office, and from the office the administrator will take them to the test area, which could be the bathroom, locker room, just wherever they have designated as their test area. The student will be given a cup to give their sample. When they're done, the sample will be given back, usually will be sealed, and the person giving the sample will initial it. From there, it'll be separated into 2 different vials. One will be taken to the lab and used by the analyzer, which has a 94% accuracy rating. If they test negative there, then pretty much the process ends. But if they test positive, then they'll move on and use the gas chromatography mass spectrometer. And that has a 99% accuracy rating. And that will make sure just to confirm that it's a positive. If it is a positive, then they'll move on to whatever the program's course of action is. Now I just put up here a list of usually the common drugs that they usually test for. It's usually not always, there's more than just this, but these are the ones that they usually test for, when what they're looking for when they do urine tests. And I also put the amount of time that it could be tested and be found positive in your sample. And alcohol could be anywhere from 6 to 24 hours. Amphetamines 1 to 3 days. Meth 3 to 5 days. Ecstasy up to 24 hours. Cannabis or marijuana from 3 to 7 days. Cocaine from 2 to 5. Codeine from 2 to 3 days. Morphine 2 to 4. Heroin 3 to 4, and LSD 1 to 3. Yes.
Does that mean that, like, if I use meth 5 days ago and then they test me on that 5th day, then it'll still?
It's possible.
Okay.
Usually the first time will be the strongest where it'll be present. They'll still have some trace elements up to 5 days, so we found. It may even be longer. But the big thing that I found that we kind of got from this was that people that are taking the drug test, if they just use it once, like 3 months ago, it's not going to affect their drug test. It's usually for someone who usually is, a chronic user, someone who uses over a period of time. It's people that are usually positive for the drug test.
Okay, so now that you know what the urine test is, we're going to go over the students' rights to be tested. And I know the other 2 scenarios, the dress code and the search and seizure, went over these same amendments, but we're going to go over them again just to refresh your memory. Can I have a volunteer to read the 4th Amendment for us? Because I know you're going to get tired of us talking. Not everybody at one time. Katie, would you read for us? Thank you.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized.
Okay, that's a long amendment, we know that. So I'm just going to point out that the words that really have to do with the drug testing. Obviously, we have the right to be secure in our persons. We talked the other day about what the persons are, anything that's on us. Well, when we're testing, our hair, breath, sweat, urine, all that is considered to be part of your person. Any bodily fluid you have possession of is on your body, that would be considered a person. So this is the part of the amendment that we're really looking at with drug testing. It also protects us against unreasonable searches. You'll find in most of our court cases there are reasonable searches. So this part doesn't really go against what the schools are trying to do. And it says, but upon probable cause. So that's just the main words that have to do with the drug testing with the Fourth Amendment. And then also, lots of times in these court cases, they want to plead the Fifth Amendment. Would anybody like to read the Fifth Amendment for me? Anna, thank you.
No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Okay, so dealing with drug testing, the main things that I'm highlighting here are that they have the right to not be a witness against himself or herself, meaning that drug testing, if you know that you have used a drug and you're about to take a drug test, some of these plaintiffs are complaining that given their sample, that they're incriminating themselves. If they know that they have used a drug within the past week or so, however long the detection period is, that them participating in this drug test is incriminating themselves. They're telling on themselves. And so they plead the Fifth, saying that, I don't have to do this because they know they're guilty. Without the due process, nor shall private property be taken for public use. Private property meaning whatever's on their person, their hair, their urine, their breath, sweat, so on and so forth. So in these Fourth and Fifth Amendments, they are part of the first 10 amendments, which are called the Bill of Rights, a little history lesson. And in the Bill of Rights, only the federal government is addressed here. They are the only ones promising to uphold these amendments. So they came up with the 14th Amendment, and the 14th Amendment adds that the states must honor the rights as well. So the first 10 amendments, only the federal government agreed to or promised to uphold those promises, and now they've added the 14th Amendment, which adds the states. It's referred to as the Equal Protection Clause, which they talked about yesterday, equal rights for everyone. I'm not going to read this to you, but I did want you to just notice that it's very similar to the other, to the Fourth and Fifth Amendments, but they do add the word state here. No state shall make or enforce any law, any state deprive any person of life, liberty, or property without due process and equal protection. So that's just a kind of review of what the students' rights are, and when they are bringing these schools to court, what they're using as their defense, that this is their rights and that the schools are violating their rights. Okay, now, what are the schools' rights? Well, the schools, they serve as state actors, and in your reading the other night with search and seizure, it told you what a state actor is. A state actor is any federal and state government or any group that is acting in a governmental way, and that is where we come in as school districts, school boards. We are acting in a governmental way, as well as city and county governments also act in a governmental way. So, as state actors, we have certain privileges. Just throwing this in, non-state actors, they do not have to uphold the Constitution or the promises in the Constitution. For instance, private schools, private programs, health spas, anything that is not run in a governmental way, that is private, they are non-state actors, so they don't have to uphold the Constitution or the promises in the Constitution. All right. Again, we've kind of already talked about this before, but when you're violating a right, there are going to be two types of rights. The non-fundamental right, which is the mild level of scrutiny. You must show reason is rational to state interest. So these are, for instance, checking your pockets, something like that. That's a non-fundamental right because it's not really invasive. And then you have your fundamental right, like your freedom of speech, freedom of liberty. If you violate that, that's a more fundamental right. It's a higher, stricter level of scrutiny. And it tells us in our book that the Fourth and Fifth Amendments are fundamental rights. So these would be considered as violating high importance, high or stricter freedoms that we have. But you must show a more substantial reason for violating these. So we have the mild ones and the stricter ones. Okay?
Now what we would like you to do is we'd like you to partner up with somebody, the person next to you. And what we're going to do is we're going to give you a note card. On the note card it'll be a person. And it'll give a little background information of them, their experiences with drugs, history with drugs. And what we want you to do is use the information on the card to come up with 2 reasons for or against drug testing. So say, for example, you get an SGA president who occasionally uses. What you would do is what we would want, who's against drug testing, what we want you to do is come up with 2 arguments of why we would not want to do why you would not want to be drug tested. So we're going to walk around and see if you have any questions or clarifications. Just give me a couple minutes to talk about it.
So you're saying
He's a football player, participating in athletics. He does not use drugs. He does not for doing drugs. Excuse me, it's for using drug testing. It's for so he's, or reasons why he's being favored of drug testing.
I wonder if just that more so than you
Yes.
wouldn't want to have been tested. Yes. No, you were principal even for drug testing.
So I'm saying
Why do you think you should want to?
Elaborate a little bit.
Well, we don't want to incriminate ourselves because we.
when it says for drug testing, that means you are for it.
Smoking the ganja.
Yeah, you're opposed to it. You don't want to be drug tested. Use drugs.
I mean, you can come up with however many you want. We just
Yeah, if you come up with more, list more. Because in a second, what we're going to have you do is we're going to have you read your card and then give your arguments.
It is coming out of.
about 30 more seconds.
We have one to go sit.
Is it on mine? She just graduated. There was another fellow, and every time I wanted sushi, she'd always go with me because she'd always give it to me. That's weird. I had it on Facebook. I said I wanted sushi, and my mom's going to want to visit today. She wrote on there, I'm not eating that. Let me see.
All right, we're gonna start wrapping
So
here.
wrap it up.
So
And then we'll
I think everybody's done except for this group, so we're gonna save y'all to last, okay?
All right. So first of all, who has a card that says they are for drug testing? Okay. So what we're going to do is we're going to have y'all talk first. So we'll start with y'all. Just read what your person is, their little background, and then give us your 2 reasons or 2 arguments for drug testing.
Says you are a football player who does not use drugs, and I am for drug testing. Reasons why is because it prevents the use of steroids and it prevents the use of other muscle enhancing drugs.
Okay. Who else had one? Okay.
No, we've already got, okay. For safer school environment.
We're a teacher.
Yeah,
That's good.
he's already said that.
Yeah, for a safer school environment and to keep students clean and healthy, because some drugs affect the mental status and it can make a distraction for others in class.
That's good. That's good. Y'all have y'all's too?
Yes.
Very
Yes.
We're the principal
Or principal.
At public high
at
school.
a public high school. We think because not only do drugs affect their mental status, so it's going to affect their learning, it's going to also affect the learning of their peers if they're all acting out. They also cause violence, which can cause not only problems in school, in class, outside of class, but it's also more work for me to have to deal with, and I would like to not have to.
That's good. First, before we move on to the ones that are against it, we're going to go over some of the arguments that we found in the cases that we had and do some research. One is the state has the interest for a drug-free community. So if they want, if the governmental agency or school wants a drug-free community, then they have the right to test students. Another one is drug abuse is a problem that goes to the core. If it's a constant problem, if it's something that's been going on for a long time, then they have the right to implement drug testing so that they can hopefully decrease the number of those who are abusing drugs. And then the big one is the athletes serve as role models for their peers. So if your athletes serve as your role models and they're doing drugs and everybody knows they're doing drugs, then you're going to more likely to have your student base is probably going to maybe start doing drugs because they look up to the athletes, they look at the athlete as the popular kid, and they want to be popular and fit in. So, and the last thing is keeping athletes drug-free helps your society at large become more drug-free. So what this is saying is it's kind of similar to what I just said. It's just said in a little different way. It's not just in schools, but outside of schools. Your athletes are going to be your role models. Your community is going to see them as as people that are participating in drug use. So you may have more people that are participating in drug use. For those who were those that were against drug testing? All right. So over here with Anna.
Okay. We are a parent with a history of recreational drug use in high school, so we used to use recreationally in high school, but we don't really know if our child does or not. So we said what people do outside of school is not the school's business. It's not affecting them in school. And then we were having trouble coming up with a second one.
And I'm just going to elaborate on what they're taught. This is probably very common, seeing as how lots of the parents of kids today, really more, I guess, older, but they were grew up in the 70s when, you know, the marijuana was not that big of a deal and everybody did it. And so what I was saying is, like, now she's a parent and she doesn't know if her kid does drugs or not, but you kind of want to be opposed to it just because they know kids will be kids, and, you know, lots of parents are real freewheeling like that and just think, you know, well, I just don't want my kid to get caught if he or she is doing it. So that was kind of the whole purpose in theirs, is that sometimes it's not even the kid that cares, but it's more so the parent, maybe because they had a history of doing it in high school. So.
Our card says you are a regular student who drives to school and uses drugs on a weekly basis. First thing, we said that we're still attending school on a regular basis, so it's not interfering with our school work, so it shouldn't be a problem. And I assume that we're not bringing the drugs to school, so I shouldn't be drug tested. And if the student was to get drug tested, we would obviously test positive, and then we would have to deal with the consequences. So we're against that.
And Lester.
We are a band member who struggles with peer pressure and occasionally smokes weed at parties.
We said the Fifth Amendment because we don't want to incriminate ourselves by taking the test. The Fourth Amendment because we have the right to everything on our body if we're carrying it. It doesn't affect their schoolwork or the participation in band, or it seems that way. They feel more accepted by peers by doing this. And then it's a home life, so it's separate from school, so really none of their business.
Those are all good arguments. The ones that we found a lot that showed up in the cases is that there's a lot of false positives. So just because we test positive doesn't mean we actually, actually been doing drugs. Urine collection in the presence of other individuals can make you uncomfortable. Is really an invasion of a person's privacy. Is there actually data out there that supports the the drug use in athletics is rampant or that it's large, is there actually documentation saying that athletes are more likely to do drugs than any other people, and then influence other people to do drugs? And then a lot of the athletes use if it's done to us, why not for the general student body? Why are we the only ones that have to get tested just because we want to participate in athletics? These arguments that are usually used and thrown out there.
Okay, so we're going to start with our cases. We've given you what the drug test is. We've told you what the school's rights are. We've told you what the students' rights are, and arguments for both sides as to who is right. So obviously, they go to court because they have not agreed, and so they have to go to court for the judge or the jury to decide. The first case that we're going to talk about is a landmark case. It's a precedent case. All the cases that we saw, they always cite this case. It's just, in every single one of them, even the ones we're not going to present, they always talk about this case. And what this is Vernonia versus Acton. It's in 1995 in Oregon. What happened here were the teachers and the students in this Oregon school district, they started to see a sharp increase in drug use in their school body. Also, disciplinary problems. So, and we know that lots of times those go hand in hand, but they started to see this problem in their school district. So they thought about it really hard. They know that drug use can interfere with athletics. They know that it can presume a higher risk. Obviously, to play a sport, you need to know, you need to be able to react. You need to have all your senses. You need to be in control of your body. All of those things when you're in an athletic competition. And so they were saying that this was presuming a higher risk for athletes to be doing drugs, because if you're playing baseball, for instance, and you have baseball hit at you, if you're an infielder or outfielder, you obviously need to be able to protect yourself from getting hit in the ball. And just the reason why we can't drive and be intoxicated or under the influence at the same time is our reaction speed is not the same. So when you're playing football, you need to be on your P's and Q's. You need to be ready, have full control of your body, your full strength, all that. So they're saying that this is a high risk for our athletes to be doing drugs and playing sports at the same time. So what happened was they had a parent input meeting, and in this parent input meeting they were talking about ways that they could fix this drug problem in their school district. So the parents unanimously came up with a thought or an idea that they would have a student athletic drug testing policy. In this policy there were 3 circumstances. The first one was that the parent and the students had to sign a consent saying that they would participate in this drug testing. The second one was that they had to undergo a drug testing at the beginning of the season, whatever their season might be. If it was a football player, they would be tested in the fall. Baseball, they would be tested in the spring before their season started. And then that they would do a random 10% of the athletes would get randomly tested throughout their season. So they had to sign this consent form saying that they agreed to all 3 of those, and they had to undergo the drug testing. Well, the complaint is at the Actons here. The Actons is their 7th grade student. He was denied the right to play football for his school because they did not sign the consent form. They said that it was a violation of his 4th Amendment rights, and they were seeking an injunction. They wanted to, what does injunction mean? They weren't seeking an injunction for this. Good, they wanted to stop it. They wanted to stop the policy until it was further decided. Alright, so it went to the district court. Like I said, the parents filed for injunction. The injunction was denied. The district court dismissed the suit and with declaratory relief. Now, I know somebody mentioned that the other day, and I didn't really know what it was, so we had to look it up. It's the judgment of a court which determines the rights of parties without ordering anything be done or awarding damages. So they dismissed this this suit, and nothing was settled. They just went back to the way it was. So, of course, the plaintiffs are going to appeal, and the appellate court didn't feel the same way that the district court did. They actually thought that these tests were unreasonable, that there was not enough evidence by the school board to make this testing legal or constitutional. So they reversed it and they remanded it back down to the district court. Well, the school board or the school district petitioned for a writ of certiorari, and which means what? Who remembers what that little word is on our midterm?
They want to go and send the case to the Supreme Court.
Good. They requested that it be sent to the Supreme Court, and the petition was granted. So once it got to the Supreme Court, they vacated the district court's decision. They said that students do not have a full Fourth Amendment rights. I was reading somewhere else where it was saying that really unemancipated children don't have their full Fourth Amendment rights yet because they are in custody of their parent or their guardian. So they don't have the freedom of liberty. They can't just go and come as they please. They still have to answer to their parents. So that was kind of a comparison that kind of thought, it kind of, made a little light go off in my head, going, yeah, that kids really don't have the full Fourth Amendment right anyways because they're already told what to do by their parents or their guardians, and so this is kind of the same thing. The school's interest in preventing the drug use was compelling. They wanted to stop this drug use. It was proven to be, very rampant in this school system. And they said that student athletes have a decreased expectation of privacy. If you're participating in something extracurricular, you have to go by their guidelines or you don't get to play. That's just kind of the way we were raised, but some people think differently. So, I was just thinking that I have to go by the guidelines of the group that I want to participate in or I can't participate. And so they said that the urinalysis test was not a significant invasion of privacy. So, the school board wins, pretty much.
The next case we're going to talk about is Todd versus Rush County Schools. Rush County is made up of, has like 5 schools. 3 elementary schools, a middle school, and a high school. The athletic director at the high school, John Wilson, he's been at the high school since 1970. He's been there for many years, has seen he's been coaching there, he's the athletic director. He saw a lot of change in the student body, how he perceived a lot more use of drugs. So he wanted to implement a program for drug testing, but not just for athletics, but also for extracurricular activities and those who drive to school. He looked at Vernonia, looked at several other programs to use as his basis for the program that he would submit to the Board of Education. Goes to his principal and to the administrators in his school and proposed the idea to them. They like it, so he proposed it to the Board of Education. At the Board of Education meeting, he presents it with very little, not very many people objected to it. A lot of people were in favor of it. But the program that was implemented would, for anyone who wants to participate in extracurricular activities or drive to school, must sign a permission slip by the parent and the student, allowing them to randomly drug test. The big difference, Vernonia, is now we're starting to get into extracurricular activities. The case states that extracurricular activities are any activity other than athletics, such as FCA, student governments, and like the band and the library club. So it gets in 1996. It gets approved and starts to get implemented. William Todd is the plaintiff, and he is I could not find actually what club. It just said he's participating in several extracurricular clubs. Could not find the exact ones. So he was picked out for random drug testing, and his parents were upset because they thought that they didn't understand why someone in an extracurricular activity had to participate, and also those who have to just drive to school. So the Tudds alleged that it went against their son's Fourth Amendment rights. So they bring a complaint up to the district court. Both sides actually did petition for summary judgment, but the court found that the side of the defendants had more information or more evidence showing that the other side didn't have enough information. So the Board of Education or the school district was granted summary judgment. I got a little confused, read it several times, but they all said that they both for summary judgment, but the school district had more evidence showing that they had more evidence showing that the other ones really didn't have enough evidence. So the plaintiff appealed. During the appeal process, the true arguments of the case were kind of presented that this is a different program than Vernonia because it's extracurricular activities. They used that the Vernonia verbiage was sports specific, so that really did not apply as a good argument because it was found that it was constitutional to test athletes, but it didn't really say anything about non-athletes, extracurricular. And then the other argument was there was not enough evidence showing that there was a drug problem. The evidence that was presented in the Court of Appeals showed that actually during the first 2 phases of the drug testing program that they implemented, 3 out of 5 on average, of the participants actually tested positive. And there were 30 people suspended the first year in the program. In the second wave, or the second time around, it was averaged 2 out of 5. So this is why the appellate court actually ended up kind of going back and affirming the district court, saying that there is actually enough evidence out there showing that there is a rampant drug use and drug problem. And then they pointed to the verbiage, went back to the verbiage of Vernonia, and said that even though it does say it's really sports specific, there is also verbiage in there that says that just because athletes could submit to drug testing does not mean that other extracurricular activities should be barred from drug testing. So they affirmed the Court of Law decision. They also pointed to the fact that this program is very similar to those that are actually approved and acceptable to the Supreme Court. So the plaintiff requests a writ of certiorari, and what anyone think that there's something different in this case, or do you think it was the same old course of action? What do you think, it was granted or denied?
Granted.
You think they were granted?
Denied.
Denied? They were actually denied the writ of certiorari because it was compelling evidence saying that this is very similar to Vernonia and it does not infringe on any of the Fourth Amendment rights of the students that are participating.
All right, and our third and last one, it's also considered a landmark case. And this is, if you search drug testing now, this is probably the one that's going to come up because this one is the most recent. It's the Board of Education of Tecumseh Public Schools versus Earls. It happened in 2002 in Oklahoma. This is Tecumseh High School. It offers a variety of extracurricular activities, and it said that at least the majority of the students participated in at least one of these extracurricular activities. So this is not like this is a small extracurricular group, and they are saying that most of them participate in at least one. I know FFA, Future Farmers of America, and FHA, the Future Homemakers of America, this is very big. We're in Oklahoma, so they're more little country. So they were these were big groups. These were big extracurricular activity groups. Well, in September of 1998, the district adopted the Students' Activities Drug Testing Policy, which required all students who were participating in any extracurricular activity to be drug tested at any time. This was the athletes, the cheerleaders, FFA, FHA, band, choir, anything that was outside of class, they were susceptible to the drug testing. They had to sign a consent, or the policy said that they had to sign a consent saying that they would submit to the testing whenever asked, that they were randomly drug tested throughout the year, and at any time of reasonable suspicion. Now this one's different from Vernonia, but more like the Todd case because it's extracurricular activities. In Vernonia, they tested them before their season and then during their season. Well, extracurricular activities go all throughout the year. Most of them do. So this is something that they could be tested at any time of the year. It's not like the football player could just lay off the marijuana for the football season, because if he's in the FFA or if he's in something else, he could be tested all through the year. So that was one big difference in them. And it said that these tests for this particular school district did not test alcohol nor nicotine. So it was mainly just the drugs. Now, he went over the testing process kind of at the beginning, but this case was a little more specific, and I want to go over it with you for just a minute, just so you can see or picture in your mind how discreet this testing process is. It says that they called them out in groups of 2 or 3 out of class. They had a faculty monitor come and get them out of class. The faculty monitor escorted them to the restroom. The faculty monitor stood outside the restroom stalls as the students were producing the sample, and when they got done, they would bring it out. The monitor or the faculty would pour it into the 2 vials for the 2 tests, the analyzer and the other long word that he taught us about earlier. So and then together the staff would seal the vials. So this is like the student is standing there and the faculty member is standing there. It's not like the faculty member is taking their sample somewhere and could do anything to it. So they're sealing it together. The student also had to sign a little consent form, write down any medications that they are prescribed, so that if it shows up on the drug test, they would have a reason for taking these drugs. And it was all put in an envelope and sealed. So I thought that was a very private process. I mean, it's not like they're saying, okay, I want all 9th grade girls go to the locker room and y'all use the bathroom in a cup. You know, it's very professional. It was very discreet. Okay, so after they do that, they send it off. When they get the results are kept very confidential. The only people that can see them are the teachers or the faculty who need to see them. Maybe like the principal, assistant principal, maybe the sponsor of that extracurricular activity or the coach. And then it says that they were put away from their educational file, which I thought was pretty cool, because just because, you know, they may be a straight A student but may have failed a drug test, that doesn't need to go in with their educational file. So this is simply for drugs. It's not to, it said it would not be given over to any law enforcement, so we're not incriminating them at all. I mean, this is just simply to prevent them from doing drugs is what we talked about earlier. That's the main reason. It's not like they're trying to catch these people. They're just trying to say, look, we're gonna test you, and if you fail, you're out of the club. And you know, when you were in high school, the clubs and the extracurricular activities were the fun part of school, so you didn't want to get kicked out of those. Okay, so does anybody disagree with the testing process? Think it could have been done differently? I think that this was the most clear way of testing, and I thought that was a great policy. I thought they did an excellent job. Okay, so one person did not think that it was a great job, and her name was actually Lindsay Earls, no relation at all, spelled differently too. But she was a member of the show choir, the band, and the academic team, and she wanted to challenge this policy as it applied to her participation in her extracurricular activities. She's saying that I'm in the show choir, the band, and I'm on the academic team. Why do I have to be drug tested? So she didn't complain about it, the athletes being tested. She said, you know, that was not brought up. It wasn't drug testing throughout the school. It was just in those extracurricular activities that were not athletics. So it goes to the district court, and as we can tell through the pattern, the district court has been pretty supportive of the school boards. It said that it justifies the policy based on a special needs doctrine, which the Supreme Court has developed through a series of cases permitting suspiciousless testing in certain situations. So the district court looks back on all these cases where the Supreme Court has found that this was constitutional and says, we're going to justify this policy, and they dismiss the case. Well, then it goes to the appellate court, and this is really where it kind of gets ugly for the school board in the appellate court. The whole point is that they say the school board cannot prove that there was a drug problem in this school. Unlike Vernonia had a huge drug problem. They said that they saw it increasing. Tecumseh High School, or Tecumseh School District, didn't have a huge drug problem. They even had teachers testifying. They had the show choir teacher testify, and she said that she didn't think any of her choir members were doing drugs. I had another teacher, a male teacher, testify, and he said he didn't suspect any. And then here, kind of where the killer came in. The assistant superintendent, and I know this is probably hard for a superintendent to testify against the school board, but when you're under oath, you have to tell the truth. Facts come out. So, the school tested in 1998 and 1999 243 students, and only 3 tested positive. 2 high school students and 1 middle school student. Because as you noticed, this was, oh yeah, sorry, thanks. 7th through 12th grade. So there were 2 high school students and 1 middle school student that came back positive. And of those 2 high school students, 1 was a baseball player and participated in the FFA, and 1 was a wrestler and participated in FFA. So what do they have in common? And sports. Good. They were both athletes, and they were both participated in FFA. So, you know, the whole athlete thing always is very prominent. You always want to say, well, the athletes need to be tested. Well, these two guys were athletes. In 1999 and 2000, there were 241 people tested. Does anybody want to guess how many were positive?
5.
2. Close. 1 tested positive, and it was a female softball player. So, using this this information, these facts, do you think that drugs is a problem in this school district?
No.
No. So the facts didn't really help support the school board any. So the district, they tried to point to other instances that had happened in their town, but most of them were relevant to the 70s. So that's really not relevant to 2002 or 1998 when this was actually filed. So the school board looked kind of bad here because there wasn't a drug problem in the school. So the decision made by the appellate court, they said this is neither a safety concern, this was not a supervision concern, evidence did not show an epidemic of illegal drugs happening. The defendants failed to demonstrate that this was a problem in their school system, and so the summary judgment was reversed, and the drug testing policy was unconstitutional, is what they said. Okay, so, of course, the Board of Education petitioned for a writ of certiorari, and it was granted. I get the 2 that were granted. Lucky me. Okay, so it goes to the Supreme Court. The Supreme Court says, again, that drug testing is a reasonably effective way of preventing drug use or addressing drug concerns, and again, they found that it was constitutional. So, same thing they kind of said in the Vernonia one, you know, students are not, don't have the full 4th Amendment rights. All over again, this comes about again, and the Supreme Court has been very, consistent. That's what I was trying to say. Very consistent on their, in their cases. They have said that this was this was a constitutional matter. Okay.
So based on all the cases that we presented to you and everything, is it constitutional to perform drug tests on public school students?
Yes.
Someone should have.
Do you think it's constitutional after all the evidence we've presented?
Yes.
Do you think yes?
Yes.
Anyone thinks no? Why do you think no?
I think I think they have a right to privacy, and I think that there should be a good cause before you drug test someone. In that last case, I've sided with the appellate court. There was no need to be wasting money in drug testing all these kids when there was like 1 or 5 were doing the drugs.
And I would say that in a lot of the cases that came up before that last case that you showed, that's exactly what they were doing. And then the Supreme Court stepped in and gave this other decision. I mean, they were saying, if you don't have a good reason, that's the thing. What's the reason for doing the testing?
That's just like saying that you don't need to have sex education in school because there's no proof that kids are having sex. You know, like it's still a preventative measure, regardless of what the facts show.
Yeah, I agree. I mean, what I'm wondering is because maybe there wasn't a lot of drug activity in that last case, is because they knew they were going to get tested and they knew they were going to get busted for it. So, like, it was a good preventative measure. If it wasn't in place, who's to say that it didn't, you know, that it wouldn't have become an issue, and then they would have spent more money trying to fix it.
The school system is not the ultimate parent
fine, but if you're disruptive to the school and you're, like, say, drug dealers are coming into your school and stuff, then that actually prevents them coming in.
Why would a parent not want their kid to be drug tested? I mean, I would want my kid to be, if it's gonna help keep them, from doing drugs, then I'm all for it.
Yeah.
I don't think a parent would be like, oh, well, some of them are, obviously, just because I think they want to come to court, but I think it's an excellent preventative measure, and I was not opposed to it at all. I don't want anything to keep my kid from smoking, drinking, having sex, doing drugs, anything like that. So I don't understand why a parent wouldn't, but
I kind of want to piggyback off what Mindy and Lindsay just said. If a parent wants their child, any child is going to get drug tested, there are ways to get around it. There are people on probation, know they have to check in with their parole officer and get drug tested, but yet they still continue to do drugs. Now, in your case with the schools who didn't find a lot of students being positive for tests, I feel that it was unnecessary because, one, you're wasting my money as somebody who lives in that city. I have to pay taxes for you in order to conduct these drug tests. So it's kind of like, if you don't have the facts saying that my school has a drug problem, don't waste my money type of thing. That's how I feel about it.
It all goes back to the officials, they're allowed to provide a safe, drug-free community, so I think it is totally constitutional.
And the cost thing, it depended, it varied from case to case, but in the Earl's case, they had to pay $4 a year for their drug test. Now,
In
his,
Todd's,
the school
picked up for it. If you had to be retested, then it was if it was more than one other retest, like if you tested positive and you wanted to retest, the first one after that would be at the cost of the school. Anything after that would be at the cost of the student. Full cost of the student.
So, even if you do think it's a waste of money, it could be the schools or the person's. To me, I think it's a legitimate waste of money, if you want to call it a waste of money. If it's going to prevent, obviously it worked because in 1998 is when they picked it up, and in the 1998-1999 school year, only 3 people were caught, and then in the next year, only 1 was caught. That's pretty miraculous if you think about high school in 1998. So I think we waste our school board and schools waste their money on plenty of other things. Why not be one that can help the whole student body?
I don't see how it's helping.
Well, it's keeping the kids from
preventing students from doing it because they don't know when the drug tests are going to happen, correct?
Yeah.
So that's what prevents it. They
That's
can't
what
ever
prevents
do
it.
it because if they knew it was going to be this week, then they would just do it up until then.
Yeah, but you have those chronic drug users who just don't care and who are going to do drugs anyway.
Well, they're not going to be
if the school catches them and there are no penalties, so I don't see what's the point.
Well, they only tested the 2. They didn't test the whole student body. This is just 243 kids that were in extracurricular activities.
So they were just going to be
just the extracurricular. Yes, they'll be removed from the club, and that means a lot. I know you played sports in high school, yeah. I'm sure, and you were in clubs. I was in everything possible. And if I had got kicked out, I would have been lost. And a lot of people are like that in high school. You want to be involved, and so it's mainly those 243, which, to be honest with you, are probably not the drug users because they are so involved.
To play devil's advocate for a moment, I know that one of the high schools here that has had historically problems with greater number of students in gangs, greater number of students on drugs, etc. One of their techniques, one of their strategies for trying to prevent some of those problems is to get kids involved in sports. As a way of preventing them from dropping out, preventing them from being in gangs, preventing them from using drugs. So this policy, in a sense, could work against that too.
Well, I kind of liked what you said earlier. I feel like if you're willing to be in extracurricular activities, it's kind of if that's one of the procedures that you have to go through, then you're signing up for that. If it's not the whole student body, then you're making a choice to be a part of that, knowing that that comes along with it. So I think that that makes it constitutional.
All right, I have a question. If you have a kid that's in play sports, whatever, and is tested positive for an illegal substance, wouldn't it be the school's duty to report that?
It depends. In her case, there was nothing outside of, it was just you were barred from that participation for from what I understand, in her case, didn't have any school discipline. In my case, in Todd, if you tested positive, it was not to limit you from, it's not to prevent you from school discipline. Wait a minute, that's what I was. You are susceptible to school discipline and even possible the test subpoenaed for criminal cases if deemed necessary by the officer, the school officer, or the county.
Which I think goes back to the Fifth Amendment, because in my cases, they weren't criminal. And so even if you did test and you knew you had been using drugs, though you just got kicked out of the club. But in his, that you would be more, in his case, you give your sample and you've been on drugs, you are criminally incriminating yourself. And that's a whole nother level. So that's where you could throw the Fifth Amendment in, saying, no, I don't want to incriminate myself, because his are going to get, in his case, they were going to turn them over to law enforcement, and in my case, they were not. So the policies are different in all these schools. It just varies from school to school. So
I did leave one thing out of mind. It could be used for school or criminal disciplinary action if you tested positive multiple times. Say you tested positive, you then tested negative to get back into the extracurricular activity or allowed to drive to school. Then if you tested positive again, that warrants proper suspicion. And then if you test positive, if that's the reason why they're testing you, then you are in line for criminal or school disciplinary actions.
Well, my question for Lindsay's case is, if you have a kid that tested positive and he's addicted to painkillers, and all they say is, okay, well, you can't be in this club anymore, then he overdoses and died, and the parents say, you knew that he was taking these painkillers and you didn't say anything. I feel like that could be entirely traumatic.
The parents are informed
about
the
just not the law
test.
enforcement.
It's just not. It's just kept separate from their educational file. So it does not go into their educational file, which prevents them from receiving an academic award
or
scholarship. It's kept separately. But it is the information is given to the people that need to know. The parents and the student are all given the information of the positive test and given a chance to appeal it or prove it or give a reason why they tested positive.
I'm not sure if you guys mentioned something about this already, but if, say we're all on a team and this side of the table are like, they're known to do drugs after the season. So like, would you just want to take their names and when the season comes around, have them only sign a paper saying that we will drug test you guys? Like, is that unconstitutional?
Yes, because that doesn't give equal rights. So it's the whole part about equal rights is it gives everyone the opportunity at random. It's just not those people that are known to do it. It's everybody.
Did you find? Sorry.
Yeah.
Go ahead.
I remember back in high school, our volleyball coach, we had a contract. She said we will not use drugs, we will not use alcohol in season. And honestly, it didn't really work. But she would run everyone when she found out there was a party. We got in trouble, and it didn't matter if we went to the party or not. It was a team thing. And everyone got in trouble.
So that she was encouraging you to hold your teammates accountable.
She disciplined everyone. She did not care if you went or not. And so everybody would be mad at those people.
Yeah. All right. So
I got a question.
Yes.
If the coach knows when the testing's going to be, and there are star athletes they think are using,
That's what I was going to ask. Now I remember what I was going to ask.
go ahead.
Did you find any cases where someone complained that a certain person had not ever randomly been chosen? Like that it kept being the same people and it wasn't these people? Because I know when I was at Georgia, certain players just happened to never ever get drug tested.
I couldn't find really anything that could prove that was the thing. I mean, there were people that alleged that they were profiled and picked out for drug testing, but we couldn't find anything that proved that they were profiled. So I mean, it's all kind of hearsay.
What you're talking about is, you know, middle school, high school
Yeah, we're-
issue.
Yeah.
And what you're bringing up is college, but I had a college student in this class, a former college student from another university who had played football, and they knew when the testing was coming, or had a pretty good idea about when it would be. When somebody would know that that was the day. This student told me that he provided urine samples for multiple people, for his roommates. There were 3 of them that shared a room. He always provided the samples for them. And the coaches let him know when it was coming. So
I just don't understand how that can happen.
I won't identify the
Doesn't it have to be a
substance.
certain temperature or something?
Yes.
Like,
It does.
Yeah, they changed it all now.
yeah, they've made it
But
more
imagine the
specific
temperature.
where the urine has to be a specific temperature, like it left your body no more than so
Because we do
long
our
ago.
testing.
I know, you're supposed to have to stand outside.
Right.
Yeah, I know that.
In college, I said they only give you,
This
they did
was-
like 2 days notice.
This would have been.
No, they don't. We tell ours, at Liberty, we told ours the night before, by the way, you will be here tomorrow morning at this time.
Yeah, that's
Well,
already
that's
told the
middle of
players,
practice.
but we, as like staff, didn't know until 2 days before that the NCAA was coming in.
Yeah.
One last comment.
Okay, I knew a baseball player for a long time, and I know that him and his friends, when they got tested, they would order this thing called the Wizinator from online. And what it did, it filtered out the drugs out of it, you know, and half the time they would get syringed.
Wow.
There's so many ways to learn.
But I would
They, you know, and of course they were
A lot of
testing them
water.
for steroids, you know, so, and other
But,
stuff.
yeah, but in these, like Dr. Roberts said, in these scenarios, most of the time the faculty member is outside of the bathroom stall. They don't carry anything with them to class, to the bathroom. They can't take their purse where they can put a Wizinator. Or, you know, they pretty much, they have to take their body. Now, in college athletics, I'm sure there's 1,000 ways to get away with it. But in our, circumstance, middle school, high school, it's not. Okay.
So what the court cases say, and then what we found, it is. Shut up. The answer is yes.
It showed up
It
earlier.
didn't show up. I don't know why it's not showing up, but the answer is yes. From what the cases we found is yes, it is constitutional to drug test.
It flashed on and off.
Go ahead.
That's okay. What happens if you deny to take a drug test? What does that result
Declining to take is an automatic positive.
Where's our yes? It was on there like 2 minutes ago. Okay.
Does it matter?
And this was a quote, not a quote, but a statement I found online from the USA Today, and it said, while testing seems to reduce self-reported drug use in the short term, it has virtually no effect on teens' plans to use drugs in the future. And we were kind of going to ask y'all for your opinions. Y'all are so opinionated. I will take a couple. What do you think? Do you agree with this? Because at first I didn't agree. I was like, well, that can't be right, because if they're not using in high school, then that's going to keep them from using. But then you forget about college. And in college, lots of times kids are exposed. So it may be helping, the drug testing is helping prevent the drug use in the short term while they're in high school, but like they said, it virtually has no effect on teens to use drugs in the future. Do you agree or disagree with this?
I do agree with that because, if you're getting drug tested in high school or whatever, it kind of stops you from doing it. But college, if you're just a random person going to college, they don't do random drug tests to the student body. So,
And also it goes back, future use is the values that are instilled at a younger age and throughout. So if you have those core values, that's what you're going to go back to no matter what.
Okay.
I was gonna say, I agree with that because we're even still seeing, it's not like we don't see athletes in the pros testing pod, we still seeing that. I mean, few and far between or, stuff like that, but they know they're getting tested, they know, maybe not when, but they know they're going to because they're held to such a high standard in the professional level.
And last one.
I was gonna say I agree with this because not everybody goes to college afterwards, and it could just be life or just like their whole social atmosphere that could just lead them to eventually doing drugs.
Yeah, you're right. Is the word no effect, that kind of, because I just think there's got to be people out there who, that when they're not exposed to it in high school, somehow that just kept them from doing it. But, so the no effect is kind of a strong word, but.
But it doesn't say it doesn't have an effect on them in the future. It says it has no effect on their plans to use in the future. What does that mean? I mean, that means
Anything can happen.
That they may plan to use them in the future,
or may plan not to.
or plan not to. It doesn't affect them because, oh, I'm not going to use because I was drug tested in high school. But, all right, that's it. Thanks all for your participation.
I was wondering where that slide was. Okay.